The next question is perhaps the most contentious, and that is, what are the responsibilities of professionals or of physicians conflicted by conscience, and by whom should these responsibilities be mandated? We have a history to confront. I refer to our country's experience with abortion and access to contraception, where conscientiously objecting physicians faced and continue to face the same question. On many occasions, whether through silence or obfuscation, physicians chose and continue to choose not to assist women to access a legal and medical service that runs counter to their personal beliefs. I respectfully disagree with the submission of Dr. Jeffrey Blackmer to this committee of the CMA. As a regulator, I submit it is naive to think that access to physician-assisted death will not be an issue, whether for reasons of conscience or geography. The provincial colleges are not in unanimous agreement on the question of conscience, and whereas it's unfortunate that there is not a unified pan-Canadian approach, this alone should not invite federal legislation. The professional and ethical obligations of a physician in this difficult situation are clearly within the objects of provincial legislation. The colleges through FEMRAC should work towards consistency, both to establish the physician's obligations and to establish the disciplinary consequences that might flow from a breach of those obligations.
We had Monday a representative from the College of Family Physicians of Canada, Dr. Francine Lemire. Yeah, you might know her. She answered very specific questions to the obligation of a doctor to provide for referee when the doctor, has conscientious objection to provide the service, the right that we now have to satisfy according to the Supreme Court decision. What is the position of the college in relation to that? Do you share the views of Dr. Lemire that a doctor cannot abandon his or her patient and say, look into the yellow page or dial, your computer to find a doctor? What would be the position of a physician, according to you, who will want to exercise his or her right of conscientious objections in relation to inform the patient where to address to get that service?
Well, I would first say that there's absolute unanimity across the country that physicians cannot abandon their patient. So the conscientious objecting physician cannot simply abandon the patient and must continue to provide care to that patient. All colleges agree with that. The difference amongst the colleges is whether there exists a positive obligation to make an effective referral, or whether they contemplate indirect referrals through another agency, whether it be the physician making the indirect referral or providing information to the patient and ensuring that the patient has the necessary knowledge. So that's the range of options. And I think we can learn from the Benelux countries' experience that over time, as a network of willing physicians becomes known, the issue of access goes down. Our college's view, and I should say this, it dovetails with a question from, I believe it's Honourable Member Cooper. We sought in our standard simply to operationalize what we thought Carter was saying. We weren't trying to make new law or expand on it. We just wanted to operate. So Carter doesn't give us clear direction there. Right? I think this is essentially a medical thing, and I think the colleges need to get a harmonized approach to it. Our approach in Nova Scotia, as we were essentially treading water after Carter, was that we recommended an effective referral, but we mandated it for the physician who could not see his or her way clear to making an effective referral, that an indirect referral be achieved by providing the patient information. There's some variety across the country amongst the colleges.
Yeah, just briefly, I'll try to be respectful of your time. Just a little confusion on the issue of conscience protection, and you did reference Carter, and it's quite clear in paragraph 132. In our view, nothing in the Declaration of Invalidity which we propose to issue would compel physicians to provide assistance in dying. And I think there would be disagreement among professionals, legal and otherwise, as to what that actually means. Does it include active referral? Does it even include the passive referral? And I don't want to get into that argument right now, but I think there is room for debate around the definition. One of my concerns is that as we approach the issues of conscience, that it's paramount. I think this committee is charged with the very simple obligation to ensure that physicians have conscience protection, and I would go as far as to say, including not to refer. There's no other jurisdiction that has legalized physician-assisted suicide or euthanasia that imposes any compelling of medical doctors to refer. So I guess I want to ensure that our worldview as doctors or whatever other practice we're in is not compromised by a set of external forces that force us to go against our conscience. And in fact, I would be concerned that in the situation with medical doctors who are compelled to go against their conscience, could there not be a serious implication of possible post-traumatic stress syndrome or other psychic issues with which those physicians might have to deal? That's a very existential question, but a more practical one. If the regulations are allowed to be developed on province-by-province case, is it not possible that a physician practicing in Nova Scotia, where the regime is more mandatory, could move, for example, to New Brunswick or some other province where there's a more lenient and what I would call more open regime in terms of allowing physicians to actually practice according to their conscience in all spheres of medicine?
I think I followed most of the questions there. All would agree that it's an open question.
Yep.
And clearly the tidiest mechanism to close the question is for legislation to define what assistance means.
Okay.
The inconsistency between the colleges was generated by the colleges all independently waiting for federal direction.
Right.
Trying to figure out how best to interpret Carter without specific direction and, quite frankly, without terribly clear legal authority.
Right.
Right. I think it remains entirely available for the colleges to come up with a harmonized approach that would follow the lead of whatever legislation is directed. Again, I'll repeat, I worry terribly about two things: that legislation intrude on the nature of the patient-doctor relationship, and I would again say with sadness that we have to confront as a profession the manner by which we dealt with access to abortion and contraception when it was illegal.
In relation to the role of the College of Physicians of Nova Scotia, when you conduct inquiry in relation to negligence, to professional negligence, what makes the distinction between professional negligence, that in some cases might be very important in terms of consequences for the bodily integrity of the person, and a criminal code offense?
Sure. So, with respect to the discussion you were having with Mr. Rusumano, I would worry that the contemplation of a hybrid type offense, a watered-down criminal charge, would have the effect of chilling physicians from providing this service, that it might act as a deterrent to consider getting into this realm of practice. The colleges often deal with complaints and conduct investigations that may overlap with the criminal sphere. There are some times when there are positively articulated obligations of the college. If, for instance, we see anything that involves sexual abuse of a minor, we immediately, per force of statute, involve law enforcement. So we would need clear direction about the criminal code provisions, and we would adhere to them. I think that there's most of the colleges, or I can't speak for most of the colleges. I can tell you that in Nova Scotia, we have an effective, close working relationship with law enforcement. If there's a matter that seems on its face potentially criminal, if we have reasonable grounds to suspect there's criminal activity, we make a determination based on the immediate public safety, which may involve suspending a doctor's license on an interim basis, informing the Crown, and then waiting for the Crown to conduct a criminal investigation. The parts work fairly smoothly.
So you have the experience of that kind of cooperation.
Sadly, sir, yes.